Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with the closing attorney acting as the holder of the earnest money. Now, there are a lot of issues to address here, so today's video is just about the form of the funds of the earnest money when the parties negotiate to have the closing attorney designated as the holder of that escrow money, trust funds, the earnest money. So when when the buyer and the seller go binding under the GAR contract forms, it states on the actual purchase and sale agreement in paragraph A5, it clearly states under the holder of the earnest money, when the buyer and the seller negotiate who is going to hold the earnest money, it states that if the holder is a closing attorney, Form F510 must be attached to the agreement as an exhibit, and then Form F511 must also be signed by the closing attorney. So in essence, what GAR has done is, since a lot of times buyers and sellers will negotiate in the evenings or on the weekends and you can't necessarily get in touch with the closing attorney to sign the form agreeing to be the holder of the earnest money, GAR has two forms. One is the F510 that the buyer and the seller can sign when they go binding if they are not able to get in touch with the closing attorney at that point, and that form is called closing attorney acting as the holder of the earnest money, and this is an actual exhibit to the contract, so it must be referenced as the exhibits, and it is an exhibit to the contract, and it must be included for the full binding contract. But this form in and of itself just designates or identifies who the closing attorney is, as well as an alternate holder for the earnest money, and the parties go binding with this form. Then there is another form, Form F511, which is agreement of the closing attorney to serve as holder of the earnest money. Now, this is just an agreement signed by the closing attorney. This is not an exhibit to the contract. The exhibit is Form F510. But anyway, like I said, there is a lot to go over with this information. Right now, I just want to talk about the form of the funds. So it states in the purchase and sale that if the buyer and the seller do choose to have a closing attorney as the holder, designated as the holder of the earnest money, then you must use that exhibit F510, and then the closing attorney must sign the agreement after the parties go binding, which is F511. So F510, and further on in the purchase and sale, it states the form of the earnest money. In paragraph A7, it says the earnest money shall be paid by check, cash, or wire transfer of immediately available funds, and then you can negotiate, X number of days after the offer date, so forth and so on. Then in that form, F510, closing attorney acting as the holder of the earnest money, which is an exhibit to the contract. Again, I'm just talking about one small part of it right now. It clearly states in paragraph 5 of that exhibit, earnest money must be wired to the closing attorney acting as holder. Notwithstanding any other provision to the contrary contained herein, the buyer shall be responsible for sending all earnest money and other buyer trust funds to the closing attorney acting as holder by wire transfer of immediately available funds, and immediately notify the seller when the same has been accomplished. This provision shall only apply if the holder is the closing attorney. So first of all, we know that regardless of what the buyer put on the purchase and sale agreement, the form of the earnest money, for example, if the buyer put that the earnest money will be in the form of a check, if, however, they've designated the closing attorney to be the holder, this is an exhibit, and we know an exhibit supersedes the purchase and sale. So regardless of what they put in the purchase and sale, if they choose a closing attorney, the funds must be wired. Now, I've done several videos on wire transfer and the timing involved with getting the wiring instructions and actually getting those funds wired to the closing attorney. That's a whole nother set of videos, but we're talking about the form. Now then, and so the parties go binding with this exhibit. So after your binding, then you must get into the hands of the attorney. The attorney must sign this GAR form 511, which is agreement of the closing attorney to serve as the holder of the earnest money. It says escrow agreement. Now, what this says is it says the terms of the closing attorney acting as holder. Basically, the escrow agreement is hereby incorporated into the agreement, and together they shall bind the closing attorney acting as the holder of the earnest money, acting as the holder. The provisions of this agreement, including the escrow agreement, related directly or indirectly to the earnest money and trust funds, may be enforced by the holder as a third-party beneficiary to the agreement. The holder shall have all the pre-printed rights, duties, and responsibilities and procedures of the holder of the earnest money that are outlined in the purchase and sale agreement. But further on down, it states that in paragraph 2 of this agreement, F511, it clearly states closing attorney must agree to become holder within 3 business days. The closing attorney shall not become the holder unless the closing attorney has within 3 business days from the date of the closing attorney receives the entire contract. The closing attorney has A, signed the escrow agreement without modification except for filling in the blanks contained herein, and B, delivered the same to the buyer and seller. So here's the issue of today's video. The closing attorney, this form 511 has a place for all the contact information, which you must fill out for notice purposes. So the closing attorney as the holder can send notice if necessary. But it clearly states that the closing attorney must sign this agreement without modification. So here's the problem we are running into. The issue is that we have closing attorneys for whatever reason. I don't know if they're not reading the form, if they're signing it without reading it, if they, I don't know what the reason is. But regardless, the issue we're running into is we're having a buyer and a seller identify a closing attorney as the holder of the earnest money. They're using the form F510 as an exhibit to the purchase and sale agreement that clearly states if a closing attorney is designated as the holder, the form of the earnest money must be by wire. Then, when the form that the actual closing attorney signs, agreeing to fulfill the responsibilities of holder, be the holder and fulfill those responsibilities, it clearly states that they must sign it without modification. Then what happens is the buyer remits the earnest money to the closing attorney as holder in another form. They're sending a personal check or a certified bank check. It doesn't say that. It says it must be a wire transfer. So right then, the closing attorney, for whatever reason, they're signing this form and then they're modifying it. They're accepting a form other than a wire transfer, which goes against what the document they just signed. So here's the point. When a buyer and a seller negotiate a contract and they agree to have the closing attorney hold it, it clearly states the form of the earnest money must be in a wire. Then if the buyer and the closing attorney agree on another form of earnest money, you absolutely must amend the contract. You can't just change the form of the earnest money without notifying the seller. The seller has agreed to the form of the earnest money being in a wire of immediately available funds. If all of a sudden now the buyer's sending a personal check to the closing attorney and the closing attorney accepts it, you have to do an amendment to the contract. The seller has not agreed to that, and you must get the seller to agree to that, regardless if the closing attorney is accepting that or not. The closing attorney must sign to fulfill the responsibilities as holder, but the closing attorney isn't an essential party to the contract. It's just the buyers and the sellers that must agree to the terms of the contract. So if the buyer and the closing attorney have changed the form of the earnest money to something other than a wire, you absolutely, like I said, I'm repeating myself now, must amend the contract to get the seller's agreement to that. And if the seller doesn't agree to that, then the form of the earnest money must be in a wire. That's what the seller agreed to when the buyer and the seller went binding and negotiated through these issues. So anyway, just wanted to bring that to your attention. There are a lot of other issues and concepts with these two forms, when you are identifying, when the buyer and the seller do choose to have a closing attorney rather than one of the brokers as a holder of the earnest money, there are a lot of issues with these forms. So read through those really carefully and make sure your buyer and your seller completely understand what is involved and the time frames and so forth and so on. And if the closing attorney doesn't sign it timely, you must identify either the selling broker or the listing broker as an alternate holder of the earnest money, and all of a sudden that person becomes the holder. Anyway, a whole nother series of videos, I guess, but just wanted to bring to your attention the form of the earnest money must be a wire transfer if the closing attorney is designated as the holder, and if for whatever reason the closing attorney accepts another form which goes against what they had signed, because if they must sign it without modification, you must amend the contract. Whew. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.